practitioner to over 2,000 attorneys. Dustin, thank you for being here.
I'm delighted to be here. When I was about 17, my family and I went for a picnic out in the desert, and I watched a couple of crazy motorcyclists blasting down a wash on their bikes, and I fell in love. About 6 months later, I was able to save up enough money to buy an old beat-up bike, and I come driving it home into the yard, and my dad was standing there. And he says, "Son, you won't have any respect for that machine until you have your first fall. And let's just hope it doesn't kill you." Well, the fact is that there are all kinds of disasters out there waiting to get you. There's the natural disasters, hurricanes and floods and water leaks and fires and electrical. There's the technological things, computer crashes and hacking and data loss and credit card and bank fraud. There's practice issues, losses of a huge client, big partnerships, disputes, and breakups. There are the intentional things. Staff and partner theft happens all the time. Accidental release of client information, loss of data in important papers. And then there's the personal, death or disability, divorce, partner health, partner disability, alcoholism, drug abuse, family tragedy. This profession has some of the highest rates of alcoholism, drug abuse, heart attack, divorce, and suicide. It happens all the time. One of them is going to happen to you. And the question to ask is, will it kill you, maim you, or just bruise you? You have a choice. You can plan and prepare knowing that one of them's coming after you, or you can be an ostrich and stick your head in the sand. And I want to remind you, too, that you're not just one gal or guy out there on a wild dirt bike. You drive a bus. And that bus is loaded with your clients who put their fortunes and their lives and their problems and their opportunities in your hands, and your family as well. All of them ride on that big bus of yours. Here's some stories you don't want to hear. My bookkeeper stole $90,000 from my trust account right after the evacuation order was broadcast. I had an experience with a firm that was going under up in Myrtle Beach, an administrator of many long years, totally loyal, totally committed, and when they finally decided they were going to have to open their books and declare bankruptcy, she came into the managing partner with a face as white as a sheet and said, "I have a confession to make. Over the last 5 years, I've charged more than $200,000 of personal stuff on the company credit card. I fired my worthless secretary and she deleted all my files from the computer system. I'll have a little suggestion on letting employees go shortly. After the tornado hit our building, I discovered my secretary had been siphoning off money from the operating account." Now, here's an important thing for you to understand. There are about 10 of the major practice disasters, and almost all of them have nothing to do with the law. It's all about management, office management, and they really didn't have to happen. The first one is failure to manage your time and procrastination, not getting things done timely, missing deadlines, frustrating, angering clients. Failure to docket or identify document deadlines, good management of scheduling and stats. Failure to manage information. Failure to get complete information. Failure to obtain client consent. One thing I want to remind you of is it's always the client's matter. You have no ethical right to decide for the client or to decide against the client's wishes. Those are recipes for loss of license. Last is, the fifth one is failure to file documents timely. Sixth is missed or unresolved conflict of interest. I always laugh, in small firms, the conflict of interest check system is usually the yell down the hall method. And that is, hey, anybody ever work with John Jones? I'm going to sue him here. The next is 55% on average of all grievances at bar associations across the country relate to poor client communications. It's not just frustrating, it's not just grievance material. It can put you into a situation for a malpractice suit and eventual loss of your license. Client communications is first, and it goes back to that rule number one. It's always the client's matter. Failure to follow client instructions, a version of that failure to get consent. Only two relate directly to the practice of law: inadequate discovery and investigation, and failure to know and apply the law. So you have the ability to remove or minimize 8 of the 10 most common practice disasters through better operations. What's the recipe for a disaster? Poor, missing, or unenforced policies and procedures and processes. If you don't have those in place, the ABA has a sample law firm policies and procedures manual which can be of great help. So here are the processes that you need to control to avoid those things that are avoidable. First is your intake process. This is where a lot of things go wrong. Sloppy intake process. Your file opening process, things get lost, things get delayed along the way. I've been into PI firms that have taken in matters that have not had anything done to them for 6 or 8 months. They have been sitting, waiting to move forward. Conflict of interest check process. This can be death. You step inadvertently into a conflict of interest and it can be a horrendous experience. Visitor and telephone call management. One of the things that I do when I work with firms is I very often, although I may have a scheduled appointment, let's say 9 a.m. tomorrow, I will stop by the office the afternoon before and casually walk into the office and ask to see someone and see just how far I can get into the office before being stopped. So in most cases, I can just wander on back, walking down the halls, observing things on people's desks, observing open files. A really, really horrendous problem. Email and text message management. One of the problems I have with most case management software is that they very inadequately manage emails, and almost no one actually manages text messages. Emails are legal communication, and as such they should be a part of the client file. It's also a part of your information as to where the case stands, what the client said, what you sent to them, any information that you may have overlooked. When that email resides someplace else, over there in an Outlook file, that, yeah, if I have to find it, I can go over there and find it, that's little or no support in running an effective matter and getting effective results. Text messages are truly dangerous. I have a basic rule about text messaging, and that is don't with your clients. And because you're going to anyway, Never, never, never give anything that could be even remotely construed as legal advice in a text message, for the simple reason that texting encourages reactive thinking, knee-jerk reactions. You are far less likely to give good, solid legal advice in responding to somebody's 14-word text message. So be very, very careful. And by the way, this is a rule that you need to set forth in your firm, and you also need to sit every staff member down in a meeting and absolutely forbid them to text clients. Because that's now out of your control. Sixth is calendaring and task management. Again, missing things, sloppy scheduling, getting things delivered late, forgetting to do things, task management. Most of the new software, Clio, MyCase, Houdini, Firm Central, most of them have just exceptional task management capabilities, and yet I see very few people using them effectively. File closing and archiving. I have been into real estate firms where you can walk into a room and see hundreds, if not thousands, of files where the closing has been complete, but the file has never been completely closed. And that often means, by the way, that a title company doesn't know they're on the hook for title insurance on a lot of those files. Absolutely unacceptable. Records management, information management, tightly controlling information and records so that you're protecting the client's confidentiality and your own ethical requirements. Client status reporting. This is part of client communications. And this is where clients get angry enough to file a grievance and sometimes angry enough to sue, because they're not getting full information. They don't get feedback from their attorney. Data file security management. Hacking is absolutely endemic these days. And I just yesterday came from a firm that had 2 attorneys, 1 employee, and 1 staff member, and they had 3 computers on a peer-to-peer network, and all of their files, more than 2 gigabytes of data, was residing on 1 computer that had never been backed up. I am aghast and horrified that this still exists today in firms with otherwise very, very smart, very intelligent people. What do you want to audit? Well, how is the firm set up? If you have a partner, there's a great deal to look at. The process of taking in new clients is important. How do you decide what clients to take and not to take? How do you manage your fee agreements and scope of work, your conflict checks? What structure do you have? What requirements do you have relating to client communications? What's your control over technology, security, and confidentiality? Going back to that firm that I was in yesterday, there was actually nobody in charge of any of the IT. We had some computers, they had them hooked up, and they were all working, but nobody really was in charge of making sure that the technology worked, that there was security, that there was control over it. Absolutely amazing. Human resources, people management. You can't grow an effective firm if you don't have at least 1 good staff member. And the path to building a good, successful legal business really relates to a business that continues to serve people, that continues to operate, that continues to do things, even when you're not there, when you're in court or when you're on vacation. I'm not talking full legal services, but making sure that things are moving, that work is accomplished, that clients are being communicated with, and that has a life beyond yours. There's an old saying, and it's actually from Michael Gerber in the E-Myth: if nothing gets done when you're not there, you don't have a business, you have a job. Financial management. I've known several attorneys in startup solo practice situations that literally manage their finances on their smartphone. I had another one that managed it with an Excel spreadsheet. That is unacceptable. And by the way, it's sort of, it's really cheap, but it can be very expensive in the end, because all it takes is getting a bookkeeper for a few hours every week to make that happen right. Insurance portfolio. Are you covered? I have a friend who does nothing but go into major corporations, and particularly, for instance, big auto dealerships, pull all their insurance policies together and identify where they have gaps in coverage or where they have overlaps in coverage. So what do you need? Natural disaster preparedness and business resumption. You are in a disaster area. It happens all the time. You just had some pretty amazing disasters with the storm that went through. In Florida, we're a little more alert to some of that because of the horrendous hurricanes that we've had running through here, which, by the way, seem to have disappeared for the last 6 or 8 years, which is great, but they'll be back. Succession, leadership, and transition planning. This is the hidden danger in the profession, and we'll talk specifically about it in a moment. Health and work-life balance. Yeah, that's a nice euphemism. Yeah, you ought to take better care of yourself. I'm too busy. Well, I want to talk about how that materially affects your professional performance. And last is marketing efforts. Why do I include marketing and risk management? I'll tell you. So there are all the tools you can ever want. Your own law practice management department, Sarah Weber, and the entire bar has tons of resources for you. Every malpractice insurer has huge resources. The ABA offers tons of stuff. And if you can't find it in your local state bar, go look at other state bars. The fact is that if you go into court because you've been sued for one of these issues, and you say to the judge, well, I didn't really know how to do that, you're dead meat. Okay, so let's talk first about structure and governance. If you have a partner, if you have more than one partner, do you have an effective partner agreement? I have been into firms of 25, 30, 40 attorneys that literally do not have a partner agreement. Or they used to have one someplace and it's probably in the files, but nobody's looked at it for 20 years. And in the meantime, they've taken in 10 or 15 partners. Incredible. So here are the terrible D's about structure and governance. Distribution. There's no agreement on distribution of profits, and usually no agreement at all. In a small firm, 2, 3 attorneys, it's usually the 2 or 3 musketeers. We all work really hard, throw it all into the pot, pay the expenses, and divide it out equally. But what happens when one person starts falling down on the job? Who can make decisions about firing or hiring or acquiring, spending money? Who is in charge? Even in a 2-attorney firm, there should be one person who's designated essentially as the managing partner who has authority for those decisions. What about dissolution? Anyone who does business law, who draws up agreements and contracts for new businesses, knows what most attorneys seem to have forgotten, and that is if you have an agreement to come together, it needs to have clauses about how you come apart or how you change the structure of the organization. And this is where things tend to explode very often. How about divorce? One of the problems of agreements, or even the lack of agreements, is if suddenly we can't stand each other anymore and we're going to split up, I want my fair share. So in other words, my shares are market value. Now we have to call in a legal, a CPA who specializes in valuing law firms. They're going to place some crazy and very often astronomical value on it. and the remaining partner or partners is going to be forced to pay some huge amount of fees. There is a direct solution for this in partnership shareholder agreements. I'm happy to share that with anyone who wants to talk with me. Death. I literally worked for 6 months with a small firm of 2 attorneys where the senior third attorney who owned all of the firm died suddenly, and his son inherited ownership of the law practice. Now, bar associations tell me that's not possible. Unfortunately, that's not what the will said. So what happens when you discover that your partner's husband or wife, who's not even an attorney, suddenly has interest in your law firm? Disability. What are the provisions? This is where the Three Musketeers, all for one, one for all, breaks down. We all worked really, really hard, and my partner got a divorce and become an alcoholic and is away for weeks at a time and is alienating clients, and I'm the only one bringing money in, and he or she still expects to get half. Debt. Who can incur debt for the corporation? Who's responsible for paying it? The solutions are a good partnership agreement with ownership percentages. By the way, 50-50 in a 2-attorney firm is absolutely stalemate in a dispute. It is not workable. Share value should always be nominal. It should be par. It shouldn't be market value. It should simply be markers for how profits are split up and liabilities are handled. Expenses. How are expenses handled? How is management handled? How revenues are shared? How we make decisions, voting and control. And again, how partnerships are dissolved. Okay, let's talk about the client intake process. Many of you have experienced this, and you wished in retrospect that you'd look a little more closely for the horns. Most attorneys have experienced that client from hell. The basic rule of intake is stop doing threshold law. Threshold law is defined as whatever comes over the threshold. And what typically happens in a law firm is when I'm really busy and making a lot of money, I get really selective and I don't take in clients that are doubtful. But when it's a little slow, my standards disappear. And I take in things that later on, and you've all experienced this, later on I said, I should have known, I had a feeling, but I took them anyway. And there you are. So you need to beware the client that has a problem outside your expertise. You don't need to be that desperate to step into a practice area that could create major problems, not only for you, but for the client. It's not doing your client a service. A client who has fired lawyers, one of the basic questions, one of the first questions you should ask a prospect who sits down with you is, have you worked with other lawyers on this matter? And if they say yes, the next question is, how many? And then you might even ask a third question if they say, if they don't give you an answer there, have you ever had a situation where you've hired and fired a lawyer? Can you explain that situation for me? Because that is a huge red flag. Now, statistically, it might be just fine. But do you want to play the odds? Do you want to play roulette? It's a warning flag that is worth observing. Okay? A client with a crash priority, they run in, they need something filed today. And all they want you to do is just that one thing. I just need you to file this by Thursday or by 4 o'clock. There's an old saying, lack of planning on your part does not constitute a crisis on my part. So be very, very careful with the clients who have a crash priority, because not only does that put a strain on you, it is probably going to signify how that client is going to be to work with. You ever had a client who comes in and says, look, I have researched this, I've studied it, I know exactly what you need to do in this situation? If you have a client that says that, stand up, shake their hand, walk them to their door, and say thank you for coming in, because they will be an immense problem. They won't be a partner, they'll be in charge. And here's one of my favorites, the client who says, well, it's not really about the money, it's the principle of the thing. When your bill comes, it won't be about the money either. So it's easy to see how much money you lost from bad clients, but it's a little harder to see the non-monetary losses. These are the clients that, because they're not paying and don't expect to pay, they don't care how much of your time they use. They're the ones that will stress you out. They're the ones that take a lot of time, so you have to do other work at other hours. They create those long hours and those nights and the weekends because you've been spending so much time being run around by these D and F clients. That means you're too busy to market or to do an effective job at managing your legal business. The squeaky wheel gets the grease. So while you're on the phone for the 4th time with that D client who is reaming you out about something, and your assistant peeks through the door sill and says that one of your A clients is on the phone, your reaction is usually to say, tell them I'll call them right back. This is how A clients become B clients, through neglect. And this is how even A clients can eventually file a grievance or even a malpractice suit, because you have allowed them, you have neglected them because they've been easy to deal with, giving time to other crises and other situations. These are the people who have you driving home at night saying, why did I ever get into this stupid business in the first place? I want you to think of the opposite. I want you to think of your best couple of clients. Think of them as people, of the work that you're doing for them, of their respect for you, they're willing to pay. And think about having an entire practice filled with those kinds of people. This is when attorneys say, I love what I do. Very often I have a client that will call me, or a prospect that will call me and say, you know, I wanted to talk with you, but you know, I'm just about burnt out. I just don't think I like the practice of law anymore. My answer to them almost invariably is it that you don't like the practice of law, or is it that you don't like how you're having to practice it today? Because if it's the first, good luck to you. If it's the second, we can fix that. This is dislike of the practice. And of course, this is where the money comes in. They're always wanting deals. You're always having to do write-downs and write-offs. This just blows the heck out of your profitability. And if it's a D client that you're struggling to get to pay, their first recourse is to threaten or actually file a grievance. So when they come in the door, you need to take a very, very careful measure of your client. And at the end of the day, you have to decide, is this a client who is going to be a danger to me and my practice? This is what leads to attorneys who get completely burned out and cynical about what they do. And that does not bode well for client care. Eventually, this is what causes attorneys to say, I think I'm going to go out and be a hermit in a cave somewhere. So, bottom line is you need to have written standards. Now, why do I say written standards? Well, written standards are about having something in writing that you can refer to at your weak moments. At those moments when you tend to be, when you tend to be vulnerable to those bad clients. So will these clients take an inordinate amount of time? Do you have that time? Are they going to pay you a reasonable amount? Are there going to be someone who is going to want to stretch your ethical boundaries, to push you into doing things that you're uncomfortable with doing? Will associating with this client damage your reputation? And in that respect, is this someone who could sue me? You know, for instance, if you have a client who comes in a very highly negative, untrusting manner, who says, all right, I've talked to 4 attorneys, I need an attorney and I guess you're it, your answer should be, no, I'm not. And you should walk them out the door. Because the last thing you want is a client who came into your practice expecting to hate and mistrust you. If that's the case, you are safer, you are less stressed, and you're going to be happier by not having to deal with that client. It ain't worth the money. So these are the people who might very well sue you. So that should be one of your primary evaluation points in talking to a new prospect. The best screening tool, in my opinion, there's an initial consultation fee. Now, I know a lot of people rebel against that, but there are ways to do that. Initial consultation fee of $50, if indeed you decide to hire me, we'll comp that for you. The reason for that is there are lots of people, and you've experienced them, who are just information shoppers. They will come in and they will take as much of your time as possible with no intention of hiring you. It also signifies, if somebody's willing to pay $25 or $250, signifies someone who trusts your ability and has respect for you. They're willing to pay some amount of initial consultation fee. It is a direct reflection of how they may be as a client. So if you're afraid of this, start with something simple, $50, $25, and we'll comp it if indeed you decide to work with me. And don't hand them an invoice. The question should be, would you be paying by cash or credit card? Because that person who doesn't intend to pay, you give them an invoice, they'll walk out with it and you'll never see the payment. So trust your gut. When in doubt, increase your retainer, make it evergreen. I hope you know what an evergreen retainer is. There is a retainer taken in, and it is replenished when it gets down to a certain level. And when it gets down below that certain level, it's a big red flag for the client. Do a credit check. It's very easy to do a simple credit check. I mean, take a credit card for that initial consultation. And if they say, I don't have a credit card, or if they give you a credit card that's rejected, you have an answer. You're probably going to be working for free on this one. And as I say, trust your gut. 80% of our communication is nonverbal. It's beyond words. So when you have an uncomfortable feeling about someone, it's the rest of your communications radar that's reading something that you may not consciously see. So when you have a discomfort about a client, you are safer to say, I'm not sure would be a good fit. Thank you for coming in. Give them some referral names or something of that sort. And remember, a client who you were uncomfortable with in the beginning, it's probably going to be more so as that progresses. And that's going to be one of the causes for your stress and your cynicism and your dislike of the practice and your burnout. So life's too short to work with people you hate. So you need an intake form to manage that initial process. You need to have a standard way to gather information so that you can check for conflicts. That's one of the most important things. Set up the file properly, identify any critical dates, and determine if this is something that you should be handling honestly. By the way, let me go back to that point about working within your expertise. Sure. One of the most important things that you learned in all of those years of school is how to figure things out. But two things happen when you take something in that is outside of your expertise. Number one, you've got to do a lot of studying and research that very often you can't even bill for in order to do that. So it's very, very inefficient. And number two, you are less likely to do it right or to do it really, really well. If you are committed to client service, when a client comes in with a matter that is not inside your comfort zone, the best service you can give them is to refer them to someone who's good at that. So understand that this is an ethical issue, not just a financial issue. If you're serving a client doing something that you're not familiar with, you're not providing the level of service that you should. Or at the very least, you're doing it at a dramatic discount because of the time it's taking. So this gives you the opportunity to evaluate them for acceptability. Do they have reasonable expectations? Always listen for the expectations. I have known personal injury attorneys who achieved what they considered as fabulous settlements or verdicts for a client in a matter and have been sued for malpractice because the client said, you screwed up, you should have gotten me twice that much. Do they have a realistic timeline? This is the crisis one again. Do they expect that you can get through this in 2 weeks? Do they understand the typical length of time this may take? Do they have the ability to pay for your services? Because one thing that happens with lawyers is they get trapped. I had a firm in Milwaukee that had 13 attorneys. One attorney, 4 of them had been bar presidents actually. One of them was a family law attorney who was superb at marketing and creating new clients. Unfortunately, they had almost $1.2 million accumulated over the last 4 years of uncollected billings because this attorney would take anyone in who could give them the retainer, and then he would just happily go ahead and work on those matters, billing and billing and billing, and those bills were accumulating and not getting paid. So it's important for you to make sure that they're going to have to do your best to understand, to get a sense of whether or not they're going to be able to pay for all of your services, not just half of your services, not just the first part. Have they fired other attorneys? An important question that will be right on your intake form. Do we have the resources and capacity to handle? One of the places firms get into trouble is they're too successful and they take matters in way beyond their capacity to handle them. The result of that is very often catastrophic. Matters that go unserved, untended, deadlines missed, inadequate management, calendaring, review of files, file setup, all of that, and creates a huge crash at some point. One of the other problems in that situation, a little less visible, is that when you have a firm that lives in constant crisis, at constant 150% capacity, in constant stress, you lose good staff. And that just exacerbates the problem and creates an even bigger problem for you. Do we have the needed expertise? So my suggestion on having a form that's a client intake form, it's not just to gather information. It's actually a kind of rating form that reminds you to ask certain questions, find out certain information, and be able to see in writing how it all adds up, to give you a little more strength to say, even in slow times, I don't think we're a good fit, or I don't think this is something that I can serve you well on. Thank you for coming in. And that may allow you to go home that night and relax. So I have a lot of different forms, and I'm happy to share this with you. As we go forward, I'll be mentioning a number of forms and articles and pieces of information, and at the end of this, I'll let you know how to get them from me. All you have to do is send me an email and request them. I'll give you that information at the end. So there are forms for initial inquiry and for client intake form. Okay, fee agreements. Let's talk about fee agreements. Always, 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 always. I don't care if it's a $500 something. You need it in writing that that client agreed to hire you, that explains to them exactly what you're going to do for them, and that they agree to pay for it. A handshake, what's the old saying? An agreement is, a verbal agreement is worth the paper it's written on. And lawyers of all people should know that. It's amazing how many lawyers do not go through this process. And of course, one of the reasons is, well, I don't want to insult them. We've kind of agreed. There are all sorts of ways that you can set up that fee agreement, that retainer agreement, that getting that signature and that permission in a very, very simple, perfunctory way that does not have any upset for the client. I'm happy to talk with you about that. And the most important things of a fee agreement is delineating specifically what you're going to do and what you are not going to do. Because a vague fee agreement, a vague retainer agreement that says, I'm going to draft a will for you, you could discover that you've drafted 14 different codicils and pieces and addendums and everything else because all you said is, I'm going to do your will, and you didn't define exactly what work you were going to do. Clearly define your payment terms. The retainer or evergreen, if you're going to use an evergreen, explain the process, how we bill, how we expect payment, how we do collections. If you can, well, you should always put in your agreement a right to request withdrawal of representation for non-payment. Now, a lot of you are going to say, well, I can't withdraw. You can always request to withdraw. And very often the client doesn't understand the difference. So a client who's not paying, who is difficult to work with, that you are now appointed by the court and you're their attorney, a letter saying, if we have not received payment by this date, we will file a request to withdraw with the court. Very often that will elicit payment. Does your state allow you to file liens for unpaid balances? If so, it needs to be noted in your agreement. Mandatory arbitration. Don't allow a dispute to be taken to court by the client. A venue. All of these are basic issues for anyone who's drawing up contracts. So be very careful that your contract, you're not the shoemaker with no shoes. So another piece is you have a nice agreement, I got all the right things in it, you just shove it over and say sign here. No, that's not going to work. You need to walk through all of these pieces with the client and explain them and then give them a copy in writing. What this does is it allows you later on, when a client has a dispute about something, for you to say, to hold them accountable, to say to them, do you remember in our initial meeting we discussed the clause in your agreement that said this? So they can't come back at you and say, I didn't understand that or I didn't know that. You said, remember we discussed that. So that very often will lower the tenor of a discussion. Okay. How do you avoid a crash? This picture always just kills me. There's two beautiful old Camaros, totally destroyed. Oh. The first thing I want to say is you can't remember it all. It all needs to be written down. You need a comprehensive database that is maintained diligently. This is one of the problems with people who have databases. Well, it's not really up to date. Then it's not a database, it's just a collection of words. Is consistently checked. It needs to be, you need to have a conflict of interest form, check form, that is filled out to verify that certain steps were taken, including the database check. That should go in the client file. You also want to try to identify not just actual, but potential and perceived conflicts of interest that drills down beyond just the name to a company they own or work with, to boards of directors, to officers, things of that sort. You don't want to discover that you're suing on behalf of a client, suing a company that one of their board members is a client of yours. That is a bad situation. Client communications. What are the essential components here? First of all, you need a process that's planned in the beginning, not just sit down, have a chat, and have them fill out a form, so forth. You need to have them understand, for instance, there's a lot. Understand the difference between a client interview and client education. Part of the purpose in that discussion is to have them understand what you're going to do for them, how it's going to work, what their role in it is. So, for instance, the client that thinks you can handle this in a week, you need to be able to say to them, here's how these things usually go, here's approximately how long it might take, here are some of the complicating issues that may come up that might stretch it out. You want to make sure that they meet personally, if possible, anyone else that they will be working with. This is one of the causes for grievances. I can't ever get a hold of the lawyer. I end up talking with some yahoo in there. I've never heard of them, and they try to stonewall me. Well, when you bring your paralegal in, introduce them, praise them a little bit, have them make eye contact and handshake, then when that client calls, it doesn't get you but gets that paralegal, they're liable to say, oh, hi Fred, hi Jenny. There's that issue of I can't get through the lawyer begins to decrease. Find out what's the most effective way to communicate. Do they want it on paper? Do they want us to mail all copies of stuff? Do they want it emailed? How do they want to work? What is their choice? Explain to them how you respond to things. If they have an inquiry, how soon will we get back to them? What's the process for a response? What they're going to get copied on. I have a neat little procedure here when you're copying people on a lot of things, because this is one of the places that they get panicked. They get a big manila envelope with a whole bunch of stuff in it, and they panic and they call you. There's a way to manage that very, very effectively. Talk to them about the retainer, the purpose of the retainer, how you bill, what the payments are for, how you handle your accounts receivable. All of this needs to be. Understand that most people that come into an attorney have rarely, if ever, been in another attorney's office, never had to use an attorney. And so for them, this entire process is totally mysterious. And it's important for you to lay out as much as you can how this whole thing's going to work, what's going to happen, what kind of costs are going to be involved, how long it's going to take, when can you expect to get back to us when you call, all of these things. Because if you don't do that, they'll make it up for themselves, and you'll get to be wrong. I don't understand. I just hired him last week. I called him, and he still hadn't called. I called him an hour ago. I couldn't talk to him. You can just kind of hear what happens when people don't know what to expect. You got to understand, they come into you worried. I'm going to have to work with a lawyer. So they don't come in, oh, this is nice, everything is okay. They come in already on alert. And so anything that is off of what they expect is going to create a problem. Time up front, educating your client in detail can create a great set of efficiencies. First of all, it's going to save you a lot of time later in explaining things, a lot of unhappy client, a lot of stress. It's going to actually get you paid faster. It's going to reduce the potential for grievances and suits, which comes with consequent damage to your reputation. Understand that billings are not just a necessary evil, they're part of the client communications process. So you should always send billings out promptly and regularly. don't get caught in the trap of, well, I haven't done anything for 2 months, so I haven't sent a bill. The client is wondering what the heck is going on. When you send them a bill that says no charges this month, you now have a happy client because they haven't had to pay anything. So for sure, send out bills, just courtesy notices, even when there's no charge. Make them easy to understand. One of the things that really gets clients stressed out is these long lists of 0.2 for this and 0.5 for that and 1.6 for it, and all of these things. Turn it around. Make them about results rather than time spent. So, and the other thing is always show them the amount of time you spent that you're going to write off as a courtesy discount. Don't just say, well, I didn't bill them for that. They don't know. It's important for them to see how much time you spent working on their matter and how much courtesy you're going to give them in lowering their bill. A couple of things to try. One is a narrative billing, and with that, a summary billing. A narrative billing is a memo that's a cover to the invoice that says something like, we've made significant progress in your matter this month, we've had conversations with, and we deposed this, and we did. Give them some idea of what you actually did, not just the time that you spent, not just those little tiny things. Narrative billings about what we did this month. Then you can do a summary billing connected to that that says attorney hours 12.2, paralegal hours 6.8, miscellaneous charges $126, total invoice this much, detail billing on request. 90% of your clients will never ask for the detail billing because what they really want to know when they get a bill is what they do, what am I paying for, where are we? And bills rarely communicate that. So you can create billings that support the client relationship and make them much more happy to pay them. Don't get lost in the 0.2, 0.6 game because that's just what time you spent. That doesn't explain to the client what you actually did or achieved. So there are some articles on this as well, 4 steps to building great client relationships, and one that I wrote specifically for my family law attorney clients, how to protect your practice from crazy clients. A lot of good tips in both of those articles, and I'll tell you how to, how to get those at the end. Let's talk about technology, security, and confidentiality. It's still a huge, miserable issue in the legal profession. You have an ethical obligation to effectively manage your information, your records, your documents, and your storage. It's an ethical obligation. So the first place is to back up your data. And by the way, you want to try to back it up daily, and you want to actually look at it and verify it's there. I can't tell you how many calls I've had of firms that have had computer crashes, and they said, and we pulled out our backup disk and discovered it was blank. So you have to be very, very careful to make sure that you have a backup and that it's there. One of the problems is if you have a number of computers that are, say, on a network, a lot of people will save tons of documents on their local computer and they never get backed up. So either don't allow saves on local computers or make sure that all computers are backed up. If you're using cloud storage, as many, I mean, almost most people are today, do a background check vet the vendor's financial situation because you don't want to discover that it just disappeared. Also, make sure that you're looking at the speed and the ability for you to recover that information when you need it. It goes without saying, this is an old one and it's still going on. Word documents, WordPerfect documents, track every change that was in there. So if you're not going through and eliminating the metadata, and there are programs that will clean this for you, If you're not eliminating all of that in digital files, you're setting yourself up for problems. Is your IT support your brother-in-law who's out fishing just when you had a computer crash? You need to know that your IT support is professional and is bonded if they screw up. They have some legal responsibility, financial responsibility for screw up, that they're insured, that these people are trained and certified. Your data and the ability for you to do your work is just too central, critical, essential to your operation to leave it to chance. Regularly change all of your passwords. Wi-Fi, everything. Change them all the time. Use complex passwords, multi-level if possible. And here's something most people don't realize. Every time you trade in a copier or a computer or a smartphone, or you give your smartphone to somebody, all of those systems have data stored in them, particularly copiers. The average high-speed copier has 2, 4, 6, 8 gigs of memory. They're just computers because it's all digital today. They're computers. So there is a massive amount of your critical information on the memory of the copier, of the computer, or your smartphone. What about people issues? Well, this is where most firms stay small, is because this is a constant pain. I had a conversation with a client just yesterday that he is overwhelmed. He needs to bring on more people, and he just hates the process. And he's also a little hesitant to do it because, well, you know, if things slow down, I might have to fire them. Yeah, that's when you run a business. That's part of the risk. But you need to take the time to do it right. The problem with most hiring in law firms is we're in a crisis. We need some extra hands. They can fog a mirror. Get them in here. Really, really bad decision. There's an old saying, hire slow, fire fast. So always check all references, and when you can, if they have a reference of an attorney in another firm, talk with another attorney or staff member in that same firm that's not on the reference list and get a different view. Do a complete web and Facebook search. You never know what you're going to find out there. It's amazing what people will put on those places. Pay for an official background check. You don't want to discover too late that the person who left and took your finances with them had done it before. Hire slow, fire fast. Be willing to go through the misery it takes to find the right person. You can't build a great firm without great team members. So if they're not great, move on. Wait until you find the great ones. Make sure that you have a firm confidentiality policy about taking, storing data, taking files out of the office, about control of passwords. Have employees read it over or read it to them and have them sign it. That increases their understanding of how important it is. You need a specific procedure for terminated employees. And this is my procedure. I call it the milk crate solution. Friday afternoon, you walk to their desk with a milk crate and you say, let me help you clean out your desk. This is your last day. You stay with them until the milk crate is filled with their things, and you walk them to the door. From the moment that you give them notice, they are not unattended in your office. As you are helping them fill the milk crate, you are having all of the passwords changed on your systems, and you're having a lock changed if it's possible that they have a key. In fact, I would suggest you do that regardless. Now, that sounds extreme, but what you can say is, I'm sorry we have to do this. This is the procedure that is recommended by our malpractice insurer or by ethical standards or whatever. Because what often happens is, oh, well, you know, they're okay. You know, we gave them 2 weeks notice and let them settle things out. And then next day you come in and you discover all your computers are wiped and they're gone. Never underestimate what anger and pain will do for someone who has just been terminated. So make sure everything, if they have a firm phone or computer, get it from them. Even if you have to, if they say, oh, I left it home, say, I'll follow you home and pick it up. Do not let any of that stray. Have them sign an affidavit that they have surrendered all of the firm materials and information and do not have anything left. Now, again, if they fully intend to do that, they're going to sign it anyway. But if that thought was in the back of their mind that they're going to not bring that file in that they took home to work on, this makes it very, very important and critical and a little scary, and decreases the likelihood that they might be vindictive. Protect insecure communication. Do you know that cell phones are not regulated the same way as landline phones? They're actually considered radio, and they can be tapped into and listened to anywhere. So be very, very careful what information you convey on your cell phones. Bluetooth is totally insecure. There's no way to protect it. Public Wi-Fi is a horror story. And of course, you have to moderate your voice and your comments in public places. Too many times somebody said, I heard that you were talking about me over there at the so-and-so, because you never know who's standing next to you. Okay, let's talk about managing your money. What happens? Partner theft. You have no idea how many times that happens, and that's usually a partner that is going through some kind of personal crisis, health crisis, family crisis. They become addicted to drugs, painkillers, they become alcoholics. People's standards change. That person who was upstanding and totally trustworthy go through a crisis and their personality shifts, and it happens. Employee theft all the time. Unauthorized write-offs and write-downs. That firm in Milwaukee with the 13 attorneys and the $1.2 million worth of receivables, I have no idea how that was ever permitted over that period of time. Somebody should have stopped all of that. Unauthorized charges and checks and debts. Who's controlling the checkbook, the credit cards? Just like my client in Myrtle Beach. She had complete authorization to use the credit card. And not only that, nobody was reviewing the credit card bills but her. Not working. Theft of client information of files. And here is the big issue, trust accounting. What you need to know is trust accounting is one of those penalty of death issues. This results in more loss of attorney license than just about anything else. Make sure your client understands where their money sits and your requirement to manage and safeguard that money. Make sure your staff totally understands. I had a firm in suburban Chicago that had originally been 4 attorneys, the 4 musketeers. Each one had an assistant. It had grown to 13 attorneys, but all 4 of those assistants still had complete access to the checking account, the credit cards, and the trust account. And all 4 of them were taking money out and putting money into the trust accounts. It was one of the scariest moments I've had in a law firm. You want to use a bonded CPA to monitor your trust account and make sure that it is balanced out correctly. Why do I say bonded? Bonded and licensed and insured, because if there's a screw up, they have insurance to pay. Make sure that you have written controls and you review it with your staff. Okay, insurance. What do you really need in terms of insurance? The number one thing you need is professional liability insurance. Now, there's a huge caveat here. And I want to give you an example as to how this can go really, really badly wrong. You need to ensure that every lawyer in the firm reviews the application, understands the importance of being agonizingly truthful and accurate. How do you screw up your coverage? Lie on your application. And it happens all the time accidentally. I had a firm in Lincoln, Nebraska, a very, very great marketer who does estate planning, who half the time didn't get retainer agreements, just worked on the old handshake method. I asked the managing partner, have you read over your application for malpractice insurance? One of the questions it asks is, does your firm get retainer agreements on clients? And of course, he had checked the box, yes. I said, I got bad news for you. Any suit that arises from a matter where there is no retainer agreement, number one, there's no coverage. And number two, all the rest of your coverage is going to be canceled. What else do you need beyond E&O? You need an office protection package. You need an employee fidelity bond. You need a coverage to protect your valuable papers from loss, obviously basic theft insurance, and you need some liability coverage for employee benefits. And a big gap in all of this, I have several clients who have contract employees who are running errands, who are delivering things, who are doing work, driving their own cars, and they actually pay them mileage for the time. When that person is out there on under the direction of an attorney doing something and they have an accident, the law firm is liable. Business resumption insurance. Key man life insurance. If you're the sole practitioner, you probably actually still need key man insurance because you need to know that there's going to be somebody who can get paid for coming in and taking over your practice and at the very least winding it down. But for instance, if that key man is a partner of yours, key woman, and suddenly they go down and you depended on them, you need to know that you have some financial support for getting past that problem. Excuse me. Disability insurance. Oh, please, please, again, think of what I was telling you about the health problems of attorneys. If you live under a lot of stress, you could go down with a heart attack or a serious illness in an instant. And if you are a sole practitioner, your entire practice stops. So you need key man or disability insurance to protect yourself, okay? Disaster preparedness. Do you have a plan? Or is it just, we'll figure it out? And it's not just about what we do after the tornado. It's about how we rebuild afterwards as well. The fact is that you're going to be on your own for a while. You might get some meal from the Red Cross. You might get an insurance check. But the fact is that the majority of small businesses never reopen after a disaster. So what kind of disasters are we talking about? Loss of a major client, death or permanent disability of a partner, a natural disaster, suspension or revocation of a license, yours or someone else's, theft of operating account or trust account funds. Would your firm survive if any of these happened? So you want to prepare way before it happens. You want to know that you have a plan to do it. Figure out what are the key things that can happen and then decide what would be the necessities for us to be able to resume service effectively after that catastrophe. What people support do we need? What data? What software we need? What files do we need? What are the critical pieces of information? This, by the way, is a really good reason to digitize virtually everything and make sure that that's in a secured backup location. Paper is usually gone after a serious disaster. Where would you put all of this? How would you manage with furniture and fixtures and equipment? Would you have enough reserve money to make sure that you can get past this? This is a picture from South Miami after the big hurricane some years ago. This was what the entire office looked like. So let's talk for a moment about another issue which seems alien to risk management, but it's really not. Succession and leadership and transition planning. It's really a type of risk management both for your practice and for your finances. The majority of practicing attorneys today are over 45, and more than a quarter of them are 55 and older. And most small attorneys have no plan for professional retirement. The frightening thing that I see is that most attorneys are trying to squirrel a little money away. Maybe they own a building, but they essentially assume they're going to sort of close up the practice and walk away at some point. Well, that's really not exactly realistic, because most attorney retirement planning isn't about the practice. And most retirement plans are die at my desk. That's what a lot of attorneys seem to hope. But if you had an illness or a disability or a death or CRS, or you know what CRS is, right? Can't remember. Yeah, that one. What would happen in the case of these things? See, building a succession and transition plan, the basic idea is I'm going to work with someone to transition this practice as a living thing to the next generation. What it does is it provides, first of all, some basic risk management. If you have a personal disaster, if you get ill, if you die, if you get disabled, there is another attorney who is carrying on and continue to serve your clients. It also gives you a second set of licensed hands to do and to help you quality control your legal work. I see as attorneys age, many times they still have the wisdom and the skill, but they're not as good at managing the detail. And so a second set of licensed eyes and hands actually extends their usefulness and their ability to continue practice after their detail ability is beginning to slip a little bit. But it also allows them to continue to have revenues as they're stepping back, turning that practice over to someone else, and to actually, by bringing someone in, to actually grow the firm while they're building a plan to step back. And it creates, most attorneys don't really want to retire. They want to slow down. They want to cherry pick a few clients. They want to be able to take more time off. Well, if you're a sole practitioner and you close your practice, you have no ability to do that. But if you're still connected to a viable entity that's moving forward, there's an attorney in a firm there, you have a lot more options to stay involved at a lower level. What happens, attorneys tend to be the ostrich like in the beginning of this program. You know, I don't want to think about that. At 74, they're still saying that. Well, you know, I'll just bring in an associate. We'll see how it goes. Well, without any plan, that associate is probably not going to stick around very long, or you're not going to bring in the right person to make that transition. I'll just sell the practice when I'm ready. Well, when are you ready? When you've had the heart attack and can't work? When you're ready may not be when somebody else is ready to buy it. There's an old saying, you know, the value of anything is what a willing buyer is willing to pay a willing seller. So just sell the practice is not a very, very secure option. And of course there's, you know, my associate, my partner and I have an understanding. Understandings are not plans or agreements. So the fact is that attorneys lose a huge amount of money because they don't plan, and they plan too late. They don't really know what they could expect in this situation, and they don't have any information for what they could do about it. I do a lot of succession and transition planning, and it's really tragic for me to see an attorney who's built a great reputation, who has a wonderful network of people who value them and send them referrals, just closing the door. Some young attorney is missing a great opportunity, and that senior attorney is losing a lot of opportunity to get more value. So the best risk management for senior attorneys is a succession plan. It's someone else who is actually helping to build the practice, who sees this as their future, with your support to get to that future faster, to build more success through your marketing, through your strategy and wisdom, through their ability to tag on to what you've built. And I think that's one of the really sad things that I see, is senior attorneys not giving the younger generation a chance to apprentice and to work to gain from what they've built. Again, there's an article here, Law Practice Phase 2, that I'm happy to share with anyone who is interested. So let's talk marketing for a moment. In seminars, very often I ask my attendees what they believe is the single most important thing that they do in their practice every day. And they will tell me, deliver great client service, be a great lawyer, do expert work. Well, the fact is that the single most important thing that you do every day in your practice, the single driving force, is making sure that you have clients to serve who will pay you. So a major cause of grievances and malpractice is I don't have enough money. And as a result, I can't get staff, or I can't get good staff. I can't afford the right technology. There's nobody else here to make sure everything is right. I'm taking in a lot of the wrong clients, and I'm doing surprise pro bono work because of it. And I hate the practice of law. Not really, hate how you're having to practice it. So the single most important job in your practice is making sure you have clients to serve. That may sound crass, but first of all, the primary reason for you to build a practice is so that you can have a great life. And that means that that practice has to give you sufficient income and time and support for you to have that great life. So it isn't about the legal services. You have to deliver good legal services. It's about making sure that clients want you to serve them and are willing to pay. Because frankly, if you have no clients, your legal skills are not even relevant. So there's a great emphasis today on web marketing, on social media. In fact, I'm doing a presentation tomorrow on the ethics of social media marketing. But the fact is that most people have not enough money to throw at marketing on the web. And the fact is that that's a very, very inefficient way to go anyway. The fact is that the best clients and the least expensive clients come still from personal referrals. Personal marketing to build your reputation, your network of referrals, so that you have a lot of people out there referring business to you. So the 4 core principles are pretty simple. Talking to the right people, building trust relationships, making sure they know what you do and who you do it for, and staying in contact consistently. Over the years, I've had programs, 9 building blocks, 7 keys, so forth, and a few years ago I sat down and said, it's just not that complicated. You got to talk to people who can refer you business. You got to make sure that they like you and trust you and they understand what you do. And then you got to stay in contact with them. So principle 1 says talk to the right people. Who is that? Well, You'll get consistent referrals from people who know you, like you, trust you, and are happy to help. You see, this is one of the fallacies that is in the world of personal marketing, and that is somehow you're trying to use other people, trying to manipulate other people to make you money. The best referral relationship is where that referral source sees you as a valuable resource. There's something somebody that I know, like, trust, needs help with that I can't help. And I want to put them into the hands of somebody I trust who's going to treat them like I would. And so for the most part, you will get referrals from people who see you as a valuable resource. Okay? But you want to focus, it's talking to the right people, it's about focusing on a group of people who have some consistent ability to send you the type of client you want. You don't want to do marketing by wandering around. I'll go here, see what happens, go over there, see what happens. Really, effective marketing is understanding what type of client you want and then beginning to look at who are the other professionals that these people talk to that they have trust relationships with. And those professionals are those people who I need to build trust relationships with as well. Principle 2 says trust relationships. How do you do that? Well, how do you do that with your friends? You know things, you remember things about them. In this situation, it may be a little more than you can wrap your mind around, so you want to have sort of a cheat sheet. You want to have a database where you can keep some notes, where you can schedule yourself to remember their birthday or to contact them later or to invite them to something. You make notes on where you met them and information about them. And there are lots of tools for this. If you have case management software or contact management software, or even Outlook, frankly. Not great, but it's better than none. Build a database that you can identify. These are my referral sources. And make sure that you are listening to the information that you get from them. Going out there and being a lapel grabber and being a glad hander doesn't really work. It's really about forming genuine relationships with people. So my admonition is always stop going out there thinking you're marketing and realize that at the core, building a great referral network is just expanding your network of friends, people that you like and that like you and that are in a position to help you. And the simple way you do that is exactly how you do it with your friends. Listen when they talk. Remember things that they tell you. And that way you avoid Groundhog Day. Don't sell yourself until they literally ask you for information. Make notes after every contact, and before you contact them again, review those notes. And that way you avoid Groundhog Day. You know what Groundhog Day is. You invite somebody to lunch, you go out, you have a nice lunch, you talk for a while, you go back to your office. 6 months later, you see them again, you have another lunch, you have the same conversations over and over again. All you have to do is just listen during those conversations. Go back to your office, making a couple of notes of some of the conversation. They were going off on a vacation to the Rockies. Wife just got out of the hospital. They have a son that's going away to college. All you have to do on that follow-up contact is say, hey, tell me, where did your son end up going to college anyway? How's he doing there? And for 20 minutes, all you have to do is nod and smile and listen. When you remember things about people at an unconscious level, it builds strong relationships because it says to them that they're important enough to you that you remembered things about them. And yes, you have a database. It's just an extension of your informal memory. It's not a cheat sheet. It's just an extension. My little old brain can't hold all that information, things that I actually want to remember about people. Principle 3 says educate about what you do and who you work with. And that's different than saying I'm a litigator, I do estate planning. That's the process that accomplishes something for somebody. It's not about the result or the benefit or what value you're delivering. That's just about your skill set. So for instance, rather than saying I do real estate, what are you really doing there? You're helping families move into new homes. I'm a divorce lawyer. That's pretty crass. That's pretty tough. I help people work through bad family situations. That's really what you do. I do bankruptcy. I help people work through bad financial situations. I like this one. I do collections. What do you do? Drive a big green truck around? Actually, you help people get paid what they're owed. It's not complicated. I do personal injury. There's not an attorney in the country that does personal injury. What do they go out there and hit somebody? No. What they do is they help people put their lives back together when they've been hurt or lost a loved one. They don't injure anybody. They help after the injury has occurred. And that's the real value and result of a personal injury attorney. The single most common reason you don't get business from people you know and referrals from people who trust you is, I didn't know you did that. So that's why it's really important to educate. When you go out to lunch with somebody and you're building relationship, take a moment and think about, what do they know I do and what do they not know I do, and how can I work that into a conversation so that I'm educating them. Principle 4 says consistent contact over time. What's that mean very simply? It means that that most attorneys do marketing in waves. You know, it's a little slow, I'll do some marketing. I get some more income in. And then it gets really, really busy and I don't market anymore. And then things slow down and I market. I call that flurry marketing, and it doesn't really build relationships. You go out there worried with an air of desperation on you, and marketing is an exception to your normal practice. It's not part of your normal routine. As a result, it doesn't work very well. So the difference here is simply that whenever you have a habit, you build a habit and a procedure of consistent activities over time, and what that results in is a consistent long-term increase in revenues because you're simply staying in touch with people. The result is it maintains top-of-mind awareness. One of my favorite phrases, and by this time in my life I have a whole book of all kinds of aphorisms. One of my favorite phrases is, you'd worry a lot less about what people thought of you if you realized how seldom they did. So even those people who know you and like you and trust you, they have busy lives. And so if you haven't seen them for a long time, you tend to disappear from their consciousness. So you want to be in contact with them consistently enough over time that you stay in their awareness, in their consciousness. And so you're the first one they think of when they have an opportunity to refer you business. It grows relationships. You don't have Groundhog Day. You're moving that relationship from an acquaintance to a friendship to a good friend to a lifelong relationship, which, by the way, feeds you for the rest of your career. It also means that you have habits built around marketing. It's just part of what you do every day. Great marketers don't even see it as marketing. I got to go out to that meeting. Yeah, I got to do it. You know, I'm on the board of this. I'm, doing that. I'm having lunch with so and so. It's just part of who they are and how they work every day and every week. It creates a whole new set of habits, and as a result, you become much more comfortable. Marketing becomes more effective because it's more consistent, and your revenues increase. And here's my rule of thumb for marketing activity. 5 marketing activities a week. Proactive, something that you did. Bumping into somebody on the street doesn't count. Okay, but what does count is 5 things that you initiated. Now, in good times, it's a dinner with your spouse and them and their spouse and a wonderful evening. Or a lunch, or a breakfast, or a cup of coffee. But even when you're busy, a quick email, hey, haven't seen you in a while, underwater right now, want to get together and see how things are going, how's your wife after the operation. You can do 5 proactive contacts through email in 10, 15, 20 minutes. And for that matter, throw in a few phone calls, because it's very unlikely that you're going to get someone on the first time you call them. So you're going to leave a voicemail. Well, voicemail is not as good as a conversation, but it's a little touch, it's a reminder, it's better than nothing. So too busy is no excuse, because you can make 5 proactive substantive marketing contacts a week in a half an hour. And remember, that's what feeds you. So what are the bad things about marketing? Well, we've got the traditional technician view of marketing. I'm a really good lawyer and everybody knows that, and so they're just going to come find me because I'm really good. Got bad news for you. The average consumer has no way of knowing whether or not you're really good. The reason they will come to you is usually because somebody said, hey, you ought to go see my friend Larry, I would see my friend Sharon, she's really good, she'll take care of you. So most people come to a lawyer through a referral or through something they read, and a technician who simply sits there and does good work and is invisible, again, starts to become irrelevant. The technician that has no focus on what they do or where they are in terms of, being visible in the marketplace, really dangerous. And of course, there are still attorneys that feel like marketing is dirty. Marketing is your oxygen mask. And you can do it well, you can do it ethically, you can do it in a way that you enjoy, that builds relationships and builds business. It is not what is typically assumed to be marketing. The technicians end up living on threshold law. Whatever comes through the door, and little by little their practice tends to deteriorate, even though their skills may be increasing. They're invisible. They have very little walking in the door. And then there are people who get very, very desperate. They pay illegal referral fees, not just to attorneys, but to ambulance chasers, to nurses, to so forth. There's the attorney that'll do anything, doesn't matter whether or not I know how to do it, I'll do it, and I'll do it cheap. Yeah, but it's not, it's not terrible. Yeah, sure, we can do that. I literally had a firm about 6 or 7 years ago called me in for some operational advice, and I said I need to kind of understand, where the firm is. There were 4 attorneys and 5 or 6 staff, and I said, can you share with me your financials as to what your gross revenues were last year? And the managing partner, she looked at me kind of sheepishly, said, well, it's a little hard. I said, well, can you give me a range, a number? Doesn't have to be perfect, but an approximation of what the firm's revenues were last year. And she finally looked at me and she said, well, and her eyes darted around a little bit just like that. She said, about $89,000. And I looked around and I said, really? 4 attorneys, 5 staff, $89,000? And she said, well, a lot of our fees do come in cash. I picked up my briefcase and I said, thank you for calling me. I'll be leaving now. It's more prevalent than you know. And it's not only unethical, it's flat out a federal offense. Tapping of trust accounts. I hate to say it, but I think it happens vastly more than is ever found, because often people do manage to sneak a little out of it and put a little back before anybody sees it. But the real risk here is that I'll take a bunch out and I can't get it all back in, and I'm dead. The ugly results are grievances and malpractice suits, suspensions, loss of license, criminal charges. Perfect time to talk about health and work-life balance. Because if you've gotten to that point, your practice has failed you and you failed your practice. Because the bottom line purpose of your practice is not to deliver legal services. It's to give you a good enough life that you can deliver great services. If your practice is not giving you a great life, find out how to fix it. It's fixable. It really is. It's not something. Law school teaches attorneys to have no personal boundaries. And this is one of the reasons most law firms work so inefficiently, is because the whole view is when I get more work in here, I just work more hours. I just, keep going, and I can work on Saturday, and yeah, my wife's birthday's Sunday, but I got some work to do. This is one of the biggest reasons that attorneys have this level of dysfunction, is because they have no personal boundaries. So what happens is they work and work and work, and their outside life gets missed. And that's a danger, because at some point you're simply not capable of delivering the level of service that you want to deliver. So it's fixable. This is what results, stress, poor health, overwork, and poor compensation literally endangers your ability and willingness to deliver great service. This is what creates burnout. This is what creates cynical lawyers. Shortcuts eventually results in, I was due in court and I went to the beach. Stress in the legal profession is really sort of trained in by law school, because law school is basically a test of your commitment and your will. They make unreasonable demands. They give you unreasonable deadlines. It's really kind of a boot camp. That's part of the reason is to sort things out. So what happens is that you're simply told, do what it takes to get it done. It teaches legal skills. It teaches very little or nothing about the fact that in order to deliver great legal service, you have to have the foundation of a great legal business. Very often the message is you're somebody, you're some elite special person, you're a professional, you're not a business person. Business is dirty, which is exactly the opposite. This, by the way, is one of the reasons I love to work with second career attorneys. People who have had careers outside the legal profession. They tend to come into the legal profession with a much more practical and logical view of what they do, what their role is, what their expectations are. And in large firms, they work associates till they drop. Personal lives are optional. So all of these things put lawyers out into the real world with no sense of personal boundaries. Do what it takes. Interestingly enough, this really affects how firms are inefficient, because when I can always work an extra hour, or when I just expect my staff to work Saturday and Sunday to get this done, I have no real incentive to become more efficient, to back up and go, wait a minute, we've got to be better at this so that I don't have to work on Saturday and Sunday and I can be home with my family. It becomes a trap. More work means more work hours. There's no concept of building systems and procedures for efficiency. There's no skill. They didn't learn anything about hiring or managing people, building teams. And as a result of that, very often they fall back to, look, I have gone down that road. I've tried to hire people. They're always a disappointment. They always screw up. I ain't doing that anymore. I'm just going to do this myself, and that's okay. And that attorney lives in a practice that's $100,000, $150,000 a year or less, and yet it occupies most of their life, and it never gets any bigger. And that's the person who says, about who Michael Gerber says, they don't have a business, they have a job. So what you need to do to decrease that stress is learn how to be a more effective business manager. Understand the business side of your practice, how to manage workflow, file management, how to be better at managing finances and technology and people. Inevitably, a practice that grows because the attorney, the owner of the firm, is spending more time finding and managing team to get the work done than doing all of the work themselves. Now, this sort of cuts into the billower discussion which has been going on forever, and it's one of those disincentives to be efficient that's been built into the profession. Hopefully that's beginning to fall away, but it's still there. Well, geez, if I have my paralegal do it, I can't bill it at my rate. Well, yeah, but while your paralegal is doing that, you can handle more clients at your rate, fewer hours per client, because the paralegal or your associate is doing part of that work. It literally increases your capacity. This is one of the basic things that I do with firms, is I help them get past their overwhelm by two things. Number one is increasing their internal efficiency. And number two, increasing their team so that they increase their capacity. Because firms that work at capacity tend to get stuck there. They're not taking the opportunity to grow. They're not feeding the growth of practice. So client development is a key. When you know that when you're comfortable in turning down a threshold law client or one of those doubtful clients because you have some comfort level that there'll be another good client showing up soon because of your marketing and your client development work, your practice becomes stronger and you become less stressed and less worried. So the stressors are things like staff that isn't what you need. They're inadequate, they're unqualified, they're untrained, they're unreliable, they're not there all the time when they're supposed to be, but they're cheap. They're cheap. Those type of staff are very, very expensive. And again, the part that you can't see in that is that when they're not doing the job you hired them to do, you are. And so it all falls back on you. Bad or unhappy clients, and that usually comes from overwhelm, not being able to manage your firm effectively, taking the wrong clients in, taking too many threshold law clients, lots and lots of deadlines, not enough hands to manage all of this, lack of good support and resources, lack of documented workflow processes. Part of the efficiency building, we just kind of throw ourselves at it and try and get it done rather than manage it in an effective and efficient way. And of course, the bottom line is, I see this all the time, I'm working myself to death, but I don't get to take very much home. That's a dysfunctional practice. So all of that results in cynicism and health problems, heart attacks, divorce, drug abuse, alcoholism, all of the ills to which the profession is heir to. And that is a really, really tough thing. Now, I told you that I mentioned a number of articles along the way, and here's a couple more. Technician Trap for the New Millennium and Extricating Yourself from the Stress Trap. Those are articles I'm happy to send you. So I wanted to just say that you need to be making a plan to protect your clients and your practice, and most importantly, to protect your life. It's not just risk management. It's future management. It's about making sure that your future is better and brighter and more enjoyable. You want to be building a better legal business and not just a practice that stops when you're not there. So more information is on my websites. I have two, attorneysmasterclass.com and advancedattorneys.com, which is the succession transition planning website. If you'd like to receive the articles, all you have to do is send me an email. You can either send it to Dustin at dustincole.com or Dustin at attorneysmasterclass.com. All you have to do is say, would you send me the articles from the risk management seminar, and I'm happy to send you all of these. If you'd like to spend an hour with me, I'm free. I'm always happy to chat about your practice. All you have to do is give me a call, 407-830-9810. I'm actually in a suburb of Orlando, Florida, and while I have a tie and sport coat on, you don't want to see the bottom half of me with my shorts and flip-flops on. So that's one of the reasons I like webinars. But you can call, and my assistant will set us up a time to talk. All you have to do is say, I attended the Nebraska webinar, and I'd like to talk with Dustin about my practice. We'll be happy to set that up, and we'll schedule you a time to talk. I want to thank you for your perseverance through all of this. I know this is a slog, a little bit of thick going, but I want to remind you it's about your life. It's not just about risk management. It's about ways for you to build a better life. And I'd be honored to talk with you about how you can accomplish that. Thank you for being with us. I'm open to questions. You can text on the chat. You can text me questions, or you can certainly find a way to ask those questions. And you can also send a question to me at email. See, down there is attorneysmasterclass.com, Dustin Cole, so you can use that email address as well. So do we have any questions? Do we have anyone who would like to send us a chat? Then in that case, I want to thank you for your attendance. Thank you very much.